In this voice thread, I'm going to talk about libel and freedom of the press. We're not going to spend a lot of time, unfortunately, on freedom of the press in this class just because of time constraints, right? Easily, this entire class could expand to be nothing but the First Amendment. But so I'm going to hit kind of the high points of freedom of the press, and then we're going to talk about libel. The first important idea in the freedom of the press is no prior restraints. So this is a doctrine, right? A doctrine is a principle that is generally applied by the Supreme Court, right? So viewpoint neutrality is a doctrine. No prior restraints, also a doctrine. So just to be clear, when the court says there can be no prior restraints, this means that there can be no state action that, before the fact prohibits something from being published, right? So this applies to print news media, it applies to broadcast, it also applies actually to books. Those cases just don't come up very often anymore because, it's just so well established that you can't prohibit the printing of a book. Also, it's very rare that any government agency will try to prohibit the publication of any information. Obviously, there are exceptions to this. You can't, for instance, publish the sailing dates for vessels during war. You can't publish troop locations or, indecent or obscene literature, right? So indecent actually is fine, but not obscene. So there are some exceptions to the no prior restraints rule, but they're very limited. Okay, so this comes from a case called Neer versus Minnesota. It dealt with a Minnesota statute that allowed for material that was deemed, and I quote, malicious, scandalous, and defamatory to be stopped, right? The term they use is abatement, but the publication could be stopped before it was released. So a judge issued an injunction against the Saturday Press for being, and I quote, a public nuisance, right? So this was described as, these were like scurrilous individuals. So these are people of kind of bad character who in this case happened to be correct about some of the accusations that they ran in their paper. But the paper, by the way, the Saturday Press that's being described as a public nuisance was kind of like a tabloid. So that law, it was more or less like a form of like seditious libel, right? So a lot of these things dealt with the criticism of public figures. So in Neer versus Minnesota, the court distinguished suppression of speech from punishment of speech. And this is an important point, right? So when we talk about speech being prohibitable by the First Amendment, what we actually mean is punishable, right? So nobody can stop you from saying something before you say it, right? Unless this is like one of those rare instances in, like incitement or fighting words where a speaker might be prevented from continuing their speech, right, for the purpose of protecting order. But generally speaking, what happens is someone says something, publishes something, puts some kind of expression out there, and then they are punished for having done it after the fact. And so the court says these are two different things, right? So preventing someone from speaking in the first place is not the same thing as punishing them. You can put your stuff out there and potentially risk being punished if it's, one of these categories of exception, but the state cannot rightfully prevent you from doing that in the first place. All right. So the court goes through the history of free speech and concludes that prior restraints are like one of the greatest dangers to sort of like the core of what we want from free speech. All right. And so this was really a pushback against censorship. So that's not to say that, again, like everything is allowed to be published. There are certain, usually security exceptions. But as a general rule, prior restraints are never allowed. So as I said in the last slide, there are some exceptions. Today in 2020, most of them are probably going to be related to security. There have been cases in the past dealing with obscenity, right? So prior restraints have been allowed in the cases of obscene movies. But if you look at the years when these things took place, this is all also before the Miller test. So we haven't talked about the Miller test yet, but Miller versus California is the test for whether something is obscene or not. And that is set in the 70s. So it would be really hard to prevent the release of something now because it was obscene, because it would have to pass that Miller test, which is very, very stringent. So if a state agency wants to try to prevent the publication of or broadcast of something, there are procedures that have to be gone through, right, to see if this is one of those exceptions to the no prior restraints rule. And so here's the procedure that has to be gone through, right? So there has to be some assurance of prompt judicial review, right? So it can't be like, well, this like local board is going to prohibit the local movie theater from showing this film that they think is obscene, but the court isn't going to be able to review this for another 6 months, right? So in that case, the court has said no, that is not an acceptable condition under which to exercise prior restraints. Second, there have to be efforts to minimize the deterrent effect of such actions. This deals with the chilling effect, right? There has to be some affirmative, like positive action on the government's part to send the message to the people that this isn't going to be a general sort of like atmosphere of censorship. The censor must promptly institute what are called the Friedman procedures. These come from this case, Friedman versus Maryland. But that's essentially what's being covered here. And then finally, the burden of proof to show that the speech is unprotected by the First Amendment has to be placed on the censor. Okay, so if you are a state actor and you're trying to prevent publication of something, then you have to prove why it shouldn't be published. It doesn't fall on the part of the person who's trying to put the expression out there to prove that they can. And so again, there are always exceptions to these things. But again, the lesson to take away from Neer versus Minnesota is that generally speaking, under almost every circumstance, prior restraints are not allowed. Now, regarding those security exceptions, here's one of them. You've probably heard of the Pentagon Papers case. This is New York Times versus US. This is a pretty famous case. Right there, so there have been movies about it, for instance. So there is a national security exception to the doctrine of prior restraints that was established here. This dealt with a classified report about the Vietnam conflict that was leaked to the New York Times. The New York Times published selections of it. In this case, there was an attempt to prevent the publication, right? So the government tried to prevent the publication. It went very quickly through the judicial system, right, which is in keeping with those procedures we just discussed. The court held that in this case, when the government tried to stop the publication of those papers, that it did not overcome, and I quote, the heavy presumption against prior restraint of the press. All right, so generally speaking, the press has a lot of freedom to publish whatever they want, right? So the doctrine of no prior restraints means that under almost all circumstances, there can be no legitimate interference with the press publishing something. That said, there are cases in which presses and also private individuals can be held liable, right? So when I say, so liable is not the same word as libel. Liable means that responsible in a way that there's an obligation to correct. So we're going to look at libel next. Libel is different from a lot of the other things that we've looked at. So for instance, the true threats exception to freedom of speech is a criminal issue, right? So if you are speaking to someone and you threaten them in a sense that falls into the true threats category, you could be charged with a criminal offense, right? And prosecuted by the state for doing that. Libel is different. Libel is a personal tort, right? So this is falling into the realm of civil law. As you'll recall, public law deals with the government versus the people. Criminal law deals with individual people breaking the state's laws. So again, that deals with the government and the people. Civil law deals with private parties, right? So corporations, people, whatever, but non-state actors. So libel is defined as written falsehoods that lead to defamation of character. So there are two key pieces to libel. One is that it's false, right? So the truth is always a defense against a libel suit. The second piece is that it's damaging. So some kind of damage has to be demonstrated. And this is somewhat, I won't say vague, but it's somewhat open. So in terms of things that could constitute damage, well, loss of income, right? So loss of reputation. And evidence of this might be, being the target of harassment, losing a position, even if it's an unpaid position, that sort of thing. It is possible to allege, emotional distress, but there's actually a separate tort for that we'll talk about when we get to Hustler Magazine versus Falwell. So libel is one tort. There's a different tort called intentional infliction of emotional distress that you might also see brought along with a libel suit. But for that, truth isn't necessarily a defense. All right, so for libel, written falsehoods that lead to defamation of character. If it's spoken, then it's slander. But usually you won't see slander suits, you most often see libel suits. So as I said, not a case of breaking a criminal statute, it's a tort. Until 1964, states were allowed to define their own standards for libel, right? So they might vary a lot between the 50 different states because they were all civil claims. In libel cases, you can see both compensatory and punitive damages. And this is just a sort of weird feature of civil law, right? Generally speaking, we think of punishment and we think of criminal law, right? So the state has the authority to punish people for doing things that are prohibited, right, by the law. That's what a crime is. So it's a little weird to see quote unquote punitive damages awarded in civil cases, but this is just, it's a convention in the United States. You can kind of critique it as you want. Obviously there are some things about it that are sort of logically questionable. But so you can have compensatory damages. Compensatory damages are just what they sound like. They are compensation. They are meant to correct the damage that has been done or to repair the damage that's been done. On top of that, in some cases, you might also see punitive damages awarded. The purpose of that being to send a message to the party that was at fault. If they were, particularly like egregiously negligent, they might get punitive damages, but it's supposed to be, there are damages that are supposed to repair the damage done. Those are compensatory, and then punitive damages will be on top of that, basically just to kind of slap the wrongdoer around a little bit monetarily. All right. So in addition to compensatory and punitive damages, sometimes the solution in a civil case will be an injunction. So we've heard the term injunction thrown around a bit. That just means a judicial order. So, in a libel case, there might be, for instance, an injunction to stop publishing, right, the false thing that the person has been saying. So I don't know how many of you have seen Joe Exotic, but you've got, Joe out there constantly stating that Carol Baskin murdered her husband. And so this is actually potentially a case of libel, right? He would need to prove that, she'd have to prove that it was false, or that he, had grounds to know that it was false, and also that it was damaging. And I don't think there's a lot of trouble finding evidence that it was damaging, since she has now become a meme. But anyway, so, theoretically, Carol Baskin could seek an injunction to, make Joe stop publishing his videos saying that she murdered her husband. Okay, so anyway, that's a bit of a tangent about Joe Exotic and libel. So 1798, Congress enacted the Seditious Libel Act. Remember this, right? So this is what we looked at the beginning of incitement. So that criminalized, and I quote, false, scandalous, and malicious statements about the U.S. and its representatives that might bring them into contempt or disrepute. This ended up not being a very useful precedent, though, because what happened to the Seditious Libel Act? Well, it was just allowed to expire in 1801. And then after the fact, Jefferson, as soon as he got into office as president, pardoned everybody who was convicted under that act, which sends a pretty strong message that, at least now the federal government thinks it wasn't legitimate. So all of this is to say, prior to 1964, libel law in America was kind of the Wild West, right? There wasn't a clear precedent guiding anybody. All the states could set their own standards. And so this led to some real issues. So we're going to look now at the first key libel case. The pivotal case in U.S. libel law is New York Times versus Sullivan. And I say this is pivotal because it deals particularly with the relationship between libel and the press. So one of the features of libel, which, by the way, this is a common law idea, right? Which means we inherited this from England. And common law is defined basically by it kind of like gradually evolves over time. and then it gets written down, but it exists in practice before it exists in like a codified statutory form. So this is an old offense, right? And so it has some features to it that are kind of like traditional features of libel. One of them being that libelous information has to be published. So you can see the clear connections to freedom of the press there, right? So one of the issues that the press will run into, aside from prior restraints, which have more or less been settled by Neer versus Minnesota, but there still remains libel to be contended with, because a key part of libel is publishing the information. It's very often the case that some media outlet plays at least some part in libel cases. All right, so basics of libel. The information has to be published. The plaintiff has to be identified, right? So that's the person who's being libeled. They have to be identified. This can be by name, but courts have also kind of expanded this to like indirect identification. So for instance, if I were to say, well, I'm not going to name names, but there's this woman who, has a YouTube empire, and she runs an animal rescue in Florida. And she does appear on camera often wearing this weird flower crown, and she murdered her husband, right? It's fairly clear who I'm identifying there. That was, again, for those of you who haven't seen Tiger King, Carole Baskin. But if you give enough kind of like hints to identify the person, that's enough too, right? To be liable in this case. So the plaintiff has to be identified directly or indirectly. Remarks have to be defamatory to the plaintiff's reputation. So this is to say that there has to be, this actually goes along with the next part, which is that the information has to be false. So these have to be statements of fact, right? So I can't come out and say like, oh, Carole Baskin, like she is the worst, right? Okay, well, I haven't said something that's provably true or false. That's just me kind of like opining. You can go out there and say your opinion, but you begin to edge into libel territory when you start making statements of fact. And the statements of fact have to be defamatory. So, if I come out there and say like, Carole Baskin, like she runs the best animal sanctuary I've ever seen. Those cats are so happy, right? Like obviously that's not defamatory. That's not damaging her reputation. The information has to be false, right? So again, there has to be a statement of fact, right? So for, maybe, yes, okay, I'm going to go back to Tiger King. So remember that Joe does these sort of bizarre music videos featuring someone who's like a Carole Baskin lookalike. And so, in the videos, we see Carole Baskin carrying around like a man's head and like feeding pieces of it to tigers. Well, that's not a statement of fact, right? It's heavily implied there that this is, another claim that Carole murdered her husband. But, just having a depiction of a woman, even if she looks like Carole Baskin, feeding pieces of this like dummy head to a tiger, that's not a statement of fact. So that, for instance, that depiction is not libel. So if you want to kind of like throw your opinions out there, that's fine, as long as you aren't making like a true or false statement of fact, right? Now that said, if what you're saying is true, you cannot be held responsible for libel, because truth is always a defense against a libel charge. And then finally, and this seems obvious, but we'll touch on it anyway, the last aspect of libel is that the defendant has to be at fault, right? So this is the person engaging in libel. Now, in terms of who can be at fault, this is number one, the person doing the talking, right? So, Joe Exotic being out there saying things to the world about Carole Baskin murdering her husband, he, in that case, would be at fault. But also, what about the news agencies that are publishing Joe's claims? So in some cases, and as we'll see, your book covers some of these cases in more detail, but as we'll see, the court does begin to open doors to holding news agencies responsible, right, or liable for libel claims if they haven't done their due diligence in terms of fact checking. All right, so here we see New York Times versus Sullivan, 1964. 1964, height of the civil rights era, right? And so this dealt with an advertisement that included some aspects that were critical of a public official, right? That were related to some civil rights demonstrations and issues. So New York Times versus Sullivan deals with slander and libel. The important point to take away from New York Times versus Sullivan is that it establishes the actual malice standard. Now, actual malice only applies to public officials. Okay, so public figures. That we're going to see this modified as we look at the next couple of cases. When it was decided, New York Times versus Sullivan applied the actual malice standard to libel against only public officials, right? So these were people who held public office. The argument for this being like, look, it's a fundamental First Amendment concern that the people be able to criticize the government. So we shouldn't have public officials who are sitting in office then, attacking private citizens with libel suits to try to suppress criticism, right? That's basically fundamentally undemocratic. So the court kind of like upped the standard that needed to be met for a public official to sue somebody for libel, or to sue a news outlet for libel. So actual malice is the standard. Now, this sounds like it is targeting intentions, but it isn't necessarily, right? This isn't, it sounds like, oh, we're looking for malicious intent. And that is not actually what the standard means. What the standard means is exactly what it says in the last part of the slide here. Okay, so the court held that the First Amendment protects the publication of all statements, even false ones, about the conduct of public officials, except when the statements are made with actual malice. Okay, so the first important point here is that in this case, even false statements might be protected. Right, as I said before, truth is always a defense against libel, but this opened the door to another kind of defense, which was like, oh, well, this was false. But then the question is, does that false statement reach this more stringent actual malice standard, which holds that, number one, the person who published them has to know that those statements were false, right? They have to have knowledge. It's really difficult to prove knowledge. So the other possibility is showing that there was reckless disregard for their truth or falsity, right? So this might mean that, the person who published them didn't do any research, right? They just kind of came out there and made the statement. Or maybe there was very easily accessible evidence that showed that the thing that the person was publishing was false. But, they just ignored that evidence. So this is a high standard, right, to meet. It's really difficult to prove that somebody acted with actual malice because it's hard to prove that they knew what they were saying wasn't true, or that they showed reckless disregard for the truth or falsity of what they said. So in a couple of subsequent cases, the court went ahead and then refined some of the standard that they set in New York Times versus Sullivan. A lot of this had to do, though, not with what actual malice was, but who was actually a public official / public figure. So Curtis Publishing Company versus Butts and the Associated Press v. Walker are important because these extended the standard away from simple office holders, right? So it used to be public officials. Now the standard is public figures. What's the difference? Well, there are lots of people who are in the public eye who, court media attention, who are not elected officials or appointed officials, right? They have no government position whatsoever. So this could apply, for instance, to celebrities. So now public figures have to prove actual malice before they can sue someone for libel. So again, very difficult, I wouldn't say impossible, but almost impossible standard to meet. So we see this again further refined in Gertz versus Robert Welch, Inc. This is 1972. So some other questions arise in terms of what's the difference between a public figure and a private person? So for instance, we have a 24-hour news cycle, and we have technologies now with the press that can very easily invade people's privacy. So almost anybody could find themselves, at the center of a media storm, right? So without doing anything to seek that media attention, if you're involved in, for instance, some kind of crime, or something where you've done nothing wrong and you've done nothing to seek fame, you can, you can wind up famous. So the court in Gertz versus Robert Welch, Inc. tried to make some distinctions there. So they say that private persons are different from public figures in important ways. So they say they make two distinctions. Number one, public officials and public figures have greater access to the media in order to counter defamatory statements. And number two, public officials and public figures, to a certain extent, seek out public acclaim and assume the risk of greater public scrutiny. Right. So if you are just like involved in a crime, and so you wind up, with the news media hounding you, you didn't seek out that fame, right? So actually, let's turn to Joe Exotic and Carole Baskin again. All right. So is Carole Baskin a public figure? Okay. Well, she didn't ask, first of all, that Tiger King be made into this sensational, very popular documentary at a point in history when everybody was stuck home watching TV. Okay, so she didn't seek the level of notoriety that she has. But she did seek some notoriety, right? So she puts herself out there in public as the person who runs this animal rescue. She has a YouTube channel. Okay, let's evaluate this. Do you think that Carole Baskin is a public figure? Apply the test here from Gertz. So does she have greater access to the media to counter defamatory statements, right? I mean, go on YouTube and see if you can find some interviews with Carole Baskin defending herself from Joe Exotic's accusations. Number two is a little bit more difficult, right? So having access to the media can be something that you wind up with that you never wanted, right? Because the media has just kind of hounded you for some connection to something that, you didn't necessarily want to be connected to. Number two, as I said, is a little bit more difficult. So public figures, to a certain extent, seek out public acclaim, right? So they deliberately put themselves in the public eye, and so they're assuming the risk of greater public scrutiny. So does Carole Baskin running her YouTube channel and running her animal rescue, do you think that satisfies prong number two? This ends up being important because public figures, right, if they want to sue somebody for libel, they need to satisfy the actual malice standard, right? So show that the person knew it was false before they said it, or that person showed reckless disregard for the truth or falsity of their statements. Whereas a private person only has to show negligence. What does that mean? Well, a private person just has to show that the statements were false and that they caused damage. They don't have to demonstrate knowledge of falsity. So libel laws vary in their specifics by states, but these are the broad outlines, right? So, the standards can't exceed what the Constitution sets here, right, in terms of actual malice versus mere negligence. But there's some variation from state to state within that. All right, now, as I mentioned, Butts and Walker refined the public versus private distinction, and also decrease the burden to prove malice. So this is only endorsed by a plurality. So as you'll recall, New York Times versus Sullivan sets the actual malice standard. That is knowledge of falsity or reckless disregard for the truth. So it was proposed, at least in the decision, I think it was in Butts, where, I mean, these were decided together, so it kind of doesn't matter, but it was proposed in the decision that, another indicator of actual malice is highly unreasonable conduct, right, on the part of the person publishing or the party publishing the information. So as I said, those cases were important in terms of sort of like extending coverage and distinguishing between public and private. So there were a couple of other cases that are important to note. So one of them is Time Inc. versus Hill. This says that matters of quote unquote public interest are now included in the Sullivan test, right? So libel suits are also limited are limited to that actual malice standard if the matter that's being discussed is one of public interest. So by public interest, this generally means something having to do with politics or an issue that affects the public at large. Like public interest doesn't just mean a lot of people are interested in it, right? So, for that reason, again, something like the whole Tiger King question would be different, right? So this isn't a matter of public interest. It doesn't involve, the running of government. It is just a dispute between private parties. This issue ends up being important, or this idea ends up being important because it'll come up later in Snyder versus Phelps. So there's more broad latitude to publish statements that might be libelous if the statements are about a matter of public interest. And so the roots of that come from Time Inc. versus Hill. That is then reaffirmed in 1971 with Rosenblum versus Metro Media. I will talk about Falwell versus Hustler Magazine, and also Snyder versus Phelps in the voice thread that's on obscenity. So I'm not going to get into that right now, but I do just want to kind of point out another couple of important freedom of the press cases that are, this one in particular is related to libel. So this is Gertz versus Welch, 1974. This has to do with the responsibility of the media outlet, right, that publishes defamatory falsehoods, right, or libel. So the question here is a newspaper that publishes defamatory falsehoods about an individual who is neither a public official nor a public figure liable for injury inflicted by those statements? What does that mean? Well, is a newspaper that publishes, again, damaging falsehoods about a private individual, are they liable for damages, basically, right? Can they be sued for compensatory damages, for publishing those statements? So in a 5-4 plurality vote, the court says yes, that the newspaper can be held liable for defamatory falsehoods. So here's the decision. We hold that so long as they do not impose liability without fault, the states may define for themselves the appropriate standard of liability for a publisher or broadcaster of defamatory falsehoods injurious to a private individual. What does that mean? Well, fault has to be proven, right? So some sort of responsibility for perhaps not having done their due diligence, for instance, has to be proven before a news agency can be held liable for defamatory statements. So this is designed to give some leeway to the states, but also meant to restrain the chilling effect, right? So there are limits on what the state can hold newspapers and other media outlets liable for, because they don't want this to be a kind of free hand for the states to start using libel and defamation suits to suppress the free press. Another quick point I want to touch on is the role of reporters, right? And like what their constitutional rights are. So it's a common misconception that reporters have a constitutional right to protect their sources, right? Investigative reporters in particular. That is not the case. This is not true. So there's something referred to sometimes as reporter's privilege, but this is a norm. This is not a constitutional right. So this was decided in this case, right? So Brandsburg versus Hayes, 1972, and this dealt with an investigative reporter who had observed and written some stories about illegal drug use. So he was called to testify before a grand jury, and he refused to testify or to disclose the identities of his sources. So again, 1972, this is coming off the Vietnam War. There's a lot of, things unresolved from the civil rights movement. The Black Panther Party was very active in the US at this point, and the FBI was very concerned with surveilling them. So this is kind of a piece with other cases that are closely related and dealing with similar questions. So the court ultimately found that there's a compelling state interest in requiring journalists to disclose confidential information to grand juries. So that reporter's privilege is not recognized by the US Supreme Court. They said that, in fact, this reporter could be held liable for he could be criminally charged for not disclosing his sources when the state subpoenaed him. So as I said before, reporter's privilege is kind of a norm, right? So Black's Law Dictionary defines it as, and I quote, reporter's protection under constitutional or statutory law from being compelled to testify about confidential information or sources. Obviously, under Brandsburg versus Hayes, that is not under constitutional law, right? It's not recognized. So in response to this, there are some federal circuit courts that disagree with Brandsburg versus Hayes. And so there are some federal circuit courts that have extended something like reporter's privilege, but this is entirely up to whatever judge you wind up in front of in whatever federal circuit court. So this is not reliable. Additionally, most states have some kind of form of statutory protection for journalists so that they don't have to reveal their sources, But this is, again, statutory, right? So they're referred to as shield laws. You can look up whatever state you are from in South Carolina and see if they have them. They aren't everywhere, and they're somewhat limited. So journalists' protections in terms of keeping their sources confidential they're actually fairly limited. So just to be clear, while there are shield laws, while some federal circuit courts do recognize some kind of reporter's privilege, this is not a constitutionally protected First Amendment right of the press. And in the interest of fun and relevant, but sadly not covered by your book, I just want to bring to your attention this is a federal court case, right? This is not a Supreme Court case, but it's called Madden versus Turner Broadcasting Systems. It's from 1998, and this dealt with the question of who is a reporter. So when it comes to shield laws, when it comes to circuit courts that recognize a reporter's privilege, you have to have some definition of who is and is not a reporter. Now, just think for a moment, the most recent, big investigative journalism stories, who have they been broken by? Right? So maybe it's TMZ, maybe it's BuzzFeed, right? So we don't, traditional media outlets just aren't that important anymore, right? Most people don't watch cable news. I think the average age of a cable news watcher is 70 something. Where do you get your news from? What outlets? My guess is they're not traditional news outlets, right? And so this ends up being really important because if you're going to have people doing investigative journalism, they're taking certain risks. And if they want to be protected by shield laws or, federal circuit courts that recognize reporters' privilege, they have to meet the standards of being a reporter. Well, what are those? They're from 1998, right? So these are somewhat anachronistic now, but here it is. So who's a reporter? So this federal appeals case dealt with a Pennsylvania shield law that was invoked by Mark Madden, who was an entertainer employed by World Championship Wrestling. Yes, this is a freedom of the press case that has to do with professional wrestling. So this case established the test for whether or not someone is a reporter for the purposes of claiming reporter's privilege or being sheltered by a shield law. So here's the test. 1, the person has to be engaged in investigative reporting. 2, the person is gathering news. And 3, and this is the tough one, possessed the intent at the inception of the news gathering process to disseminate the news to the public. Okay, so this means that when they started gathering the information that they ultimately later want to publish, that way back at the beginning, the purpose of gathering that information and the intent was to publish it. So this doesn't necessarily cover, for instance, whistleblowers, right? So people who just are oh, wow, I've happened into this big scandal. Why don't I document it? I don't know what I'm going to do with it later. And then, down the line, end up publishing it on BuzzFeed. So I want to raise the question, is this standard still useful? Right? Or, all of these protections that we have for freedom of the press, have they kind of been made anachronistic by the rapid change in who our news sources are and who our reporters are? All right, so that concludes our discussion of libel and freedom of the press. Next, we will turn to, there's a little bit of a transition from libel to obscenity that we'll make. So we're going to look at some cases that kind of overlap those things and then look at obscenity proper.